Can you break down this situation for me with a couple of motions that you filed against District Attorney Garza?
Yeah, so I represent APD Officer Chance Bretches and another officer. They're indicted for their actions going back to the May 2020 riots. Specifically, they're alleged to have assaulted people by firing a less lethal shotgun at rioters. Less lethal shotgun is a shotgun that shoots a beanbag out of it. It's designed to inflict pain but not cause serious bodily injury. What Chance didn't know, none of the officers knew, was that the ammunition issued to them by the department was expired. It was old. Instead of being a pliable beanbag, it had hardened. And so these beanbag rounds were actually inflicting injuries on rioters, which was never the intent. Apparently, the district attorney's office knew this, and they made plans in preparation to indict the city of Austin, the corporate entity of the police department, and charge the city with a criminal offense. The city was concerned enough about this that the city went out and hired their own criminal defense attorney, Randy Levitt, a very fine criminal defense attorney here in town. And they had negotiations about what the city could do to avoid being indicted. Those negotiations and the evidence that they had leading them to believe they could indict the city is what we call exculpatory and mitigating evidence. And it's required in any criminal case that the government provide, the prosecutors provide the defendant all the exculpatory and mitigating evidence in their possession and that they know about. And in this case, the district attorney's office failed to disclose those secret meetings, the negotiations, the evidence they had to indict the city. They never provided that to us.
So that evidence specifically being the beanbags and their the date at which they were expired?
Well, we don't exactly know what evidence. I'm surmising that they had information about beanbags to cause them to think they could indict the city. It may be something else.
Okay.
That's the point. We should have been given that. So when we get that information, we would have done our own investigation to learn more details about that to best defend our client.
Yeah. So explain to me then, how does, these, like you say, secret meetings and the lack of evidence being provided to you guys, how does that impact the case here for that Austin police officer who's being indicted?
That's a fair question, but I don't have the answer because I never got the evidence.
Okay.
And so if they had provided the evidence showing the city was criminally responsible, like they thought, then I could use that to defend my client by saying he's not the guilty one here. It was the city, the alternative suspect, the unindicted co-defendant. But they didn't give us that chance because they hid the evidence.
And then also in your motions, I saw that this also is a violation of due process rights. Can you explain to me, or for people who don't know, how that incorporates into this case as well?
Sure. Simplified, every criminal defendant is entitled to fair treatment, what we call due process. And part of that due process is receiving this exculpatory and mitigating evidence. It's not just a constitutional requirement, but there's case law, specifically Brady versus Maryland from the U.S. Supreme Court, that mandates the government turn this evidence over. And then here in Texas, we have a broader application called the Michael Morton Act, which requires all evidence, whether it's exculpatory or not, to be provided to the defense. And then if that wasn't enough, the judge gave a specific order to the government, to the prosecutors, to give us everything, and they failed to do that.
Can you go to a two-shot here?
Absolutely.
And just zoom out real quick.
It's going to be slightly over the shoulder.
That's fine.
Okay.
Let me know when you're good.
Okay, we're good.
Awesome. So then why file these motions now?
Well, we certainly just we're able to put all the evidence together to learn that this secret negotiation and constitutional violation had happened. And so we filed a motion. Our first motion was to dismiss the case. And I think that's the right remedy, because how will we ever know that we ever got all the evidence? Now, if they come forward now and say, well, here's what those meetings were about, how do we know that's all the evidence there is? You know, judges exist to make sure both sides have a fair trial. And the government has put Judge Sage in a position where she can't look at Chance Bretches and guarantee that he's getting a fair trial. And so I don't think there's any other remedy that could possibly do justice in this case.
Yeah, and just to confirm with you that throw out the case, that motion is in regards to the one you filed on Monday, right?
Yes.
Okay. Why should people at home care about this? What's the significance here to the people of Austin when we hear, motions filed against the district attorney and some other organizations calling for his immediate resignation?
Yeah, that's another great question. People should be concerned, because if it can happen to a police officer, the guys and gals that run towards danger, if it can happen to them, then it can happen to any citizen. And what I believe, I don't think it's an overstatement to say we're watching the destruction of our criminal justice system in real time.
Wow. You today filed that motion about the court of inquiry. Can you kind of explain for someone who doesn't know what that is, what a court of inquiry is?
I'm sure most people don't know what a court of inquiry is. It's an obscure and seldom used provision in the Texas Code of Criminal Procedure that allows a district judge to hold a hearing to determine if there's probable cause to believe a crime has been committed. So in this case specifically, if this motion is granted, a hearing will take place to determine if Mr. Garza and his top lieutenants committed the offense of official oppression and tampering with evidence by concealing.
Okay. So then what's your goal of that court of inquiry then? The court of inquiry then? What do you hope to see come out of that?
Yeah. Well, I'm in the business of fighting for justice. And I think in this case, justice demands a full hearing on their conduct to determine if they broke the law. And this is just because I'm not aware about this, but does the motion today have any impact on the one you filed Monday? Does it counter it in any way, or are you still calling, aside from the court of inquiry, for this case to be dismissed based on that being the withheld Absolutely.
evidence?
The case has to be dismissed. Okay. I don't expect we'll see immediate movement on the court of inquiry issue. I think that will take some months to sort out. But again, I don't see how we go forward with a trial for my client, given what's happened.
Gotcha. Is there anything I didn't ask you that you think is important to mention about the case or the two motions you filed, or moving forward, what's next?
Yeah, well, we have additional motions in the works. Okay. We expect today to file a motion requiring the prosecutors in the city of Austin to preserve all evidence related to these secret negotiations and the plans to indict the city. We think all of that evidence is relevant. It's necessary that we get it, and they have an obligation to preserve that evidence, not to destroy it, not to erase it, not to shred it. And so we'll be asking the judge for an order ordering the city and the district attorney's office to preserve all that evidence.
Okay. And that's coming out today, you said?
Well, we'll file it today. The court clerk needs some time to process it. I expect it'll actually be in effect, or we'll ask the judge to sign it sometime tomorrow.
Gotcha. Awesome. Well, sir, I think that's all I got for you then.